Ben Garrison. I am here with attorney Joe Denneler. I am the National Program Director for Elite MGA, a leading provider of home inspector E&O and general liability insurance for inspectors across the country and InterNACHI members with our insurance program that we formed exclusively for the membership. And Joe and I wanted to talk to you a little bit today about the importance of having an inspection agreement, where you can find them, the purpose they serve, and commonly and frequently asked questions about these agreements to help inspectors get a better idea of how they can be helpful and what's involved with getting a good one and what a good one entails. So with that, Joe?
Sure. You know, Ben and I are with Elite MGA, and we own a captive insurance company called Elite Re that has a unique program with InterNACHI regarding an insurance program, especially for InterNACHI members. It's a risk purchasing group, usually called the InterNACHI Insurance Program. So I manage all claims that come in for the program, and Ben is our national program manager for the entire thing. We're going to talk a little bit about the agreements in a minute, but as I said, if you need any information related to our products or services, you can go to eiipro.com or send me an email, and we'll put Ben's contact information in the chat as well for anybody that needs it. So we're going to talk a little bit about the purpose of a pre-inspection agreement, some basic contract principles that go into every agreement, some of the critical clauses that we see. We'll talk a bit about liquidated damages, and then we'll talk a little bit about arbitration clauses. The general purpose of the agreement is to protect you, right? But it's also there to educate your client on what products, services, or scope of work you're going to perform for that client under this inspection. We want to keep symmetry among all of your documents that go into the inspection. That includes the inspection agreement and your inspection report. And you should always try to make sure that those things can cohabitate together peacefully. And what I mean by that is that you're using the same terminology in the report as you do in the agreement. So if you're doing things in a state where there's no regs and you're doing them according to the InterNACHI standards of practice, in that instance, you are doing these, you are setting up your report, hopefully, to match up those standards, and your agreement should say, I'm doing them under the InterNACHI standards. And so the terminology should be equal. So you're looking in the InterNACHI standards for material defects, and you want to make sure that that shows up somewhere in your report and your agreement that tells the client, this is what I'm going to do. And then, of course, if you are in a state that's regulated, you want to make sure that your contract cites to these state regulations under which you do your work. And because we want to make sure that the consumer is fully educated about what it is you do. And more importantly, in a state that has regulations for home inspectors, they generally require that you do adhere to them. And so you want to make sure that your agreement matches those standards and what the state says you have to do. It should set out the understanding between you and your clients. And let your clients know what you will and will not do. And probably the will not do is the more important part of that equation. And it should protect you from litigation or afford you defenses against liability, some of which we're going to speak about here. Ben, my camera's going in and out a little on my end. I'm going to go. Okay. You know what?
I can see everything fine.
Okay, good. The contract needs to be easy to read. It needs to. Oh, yeah. Can you still see my screen, Ben?
Yep, I can see your screen.
Perfect. Okay. So the agreement should definitely be easy to read. It must not be unconscionable. And what we mean by that is it can't be so one-sided that a judge or an arbitrator would say, this is so tilted toward the inspector that we can't possibly enforce this agreement. And then it must inform the consumer of any important provisions and set them apart from the rest of the language in the agreement. You see I used italics and underlining and bold there. The point I'm trying to make is if there's a clause in your agreement where your client is essentially giving up some right they would normally have, or giving up the ability to bring a lawsuit against you or to seek damages above your fee, if you are in a state where we can do limitation of liability, in that situation, then you want to make sure that that language is set apart from the rest of the language so it calls the reader's attention to it. And that way they see it and they're aware of it, because when we have to enforce this agreement, when we go to court, it's much easier for us to do that if the claimant can really have no excuse whatsoever for not seeing this and understanding it when they sign the agreement. And we'll talk about this in a minute, but that also leads to the importance of getting them the agreement well before it's time for them, or time for the inspection, because we want to give them as much lead time as possible to have reviewed that agreement. So if we do have a dispute later on, they can't come back and say, well, I showed up at the inspection and the inspector just shoved the agreement in my face and I signed it and I really didn't know what I was doing, and he was already, or she was already working on the inspection anyway. We want to avoid all that, and we want to give them an opportunity to appreciate what it is they're agreeing to do and what they're agreeing to in terms of limitations on that before you actually do your work.
I think, Joe, simply put, when you look at the actual term pre-inspection agreement, it's called a pre-inspection agreement for a reason, as opposed to a post-inspection agreement.
That's exactly right.
At the expense of stating the obvious and being too remedial here, but that is, I think, a critical piece of this, in making sure that it's signed before, with ample time to deliver it, especially with today's world, with the software programs and the delivery mechanisms. Once the onboarding takes place and the appointment is scheduled, getting that agreement to them as soon as possible.
Yeah. And so here you can see the slide here that talks about, a best practice I've found. And so, I spent 20 years as a litigation attorney before I became general counsel for Elite and for our captive insurance company with InterNACHI. And this was a lot of the litigation was about interpreting and trying to enforce these agreements, because there's a lot of good stuff in there to insulate you from liability. The problem I invariably ran into a lot was what I just said. The client comes into court and says, well, I shouldn't be bound by this agreement that says I give up my right to sue for more than the fee because, the inspector threw it at me after they already did the work. Or, they have me sign it after they did the inspection. Any number of ways they can try to get out of this, they will. So I always say, key the timing of the agreement, of the sending, to when you make the appointment for the inspection in the first place. It would be in your best practice to send it out as soon as they make the appointment in some way, and make sure it's signed before you start the work. Now, some states require that, meaning that you are not allowed to start the work without a signed agreement. It could be a violation of your state regulation to do so. New Jersey is a good example of that. If you're in a state that doesn't regulate that part of your work at all in terms of when the agreement gets signed, or if you even have to use one, then in that situation, I would recommend to you that you try to send it out at least 1 business day or 2 business days after they make the appointment. So it's right there. Now, there are always going to be occasions where you can't do that. That an agent calls you on a Thursday afternoon and says, I need this inspection tomorrow. We screwed up. Can you help us out? There's going to be occasions where you can't do it in 24 or 48 hours of the time of the making of the appointment. And that's okay. But that should be the anomaly. That shouldn't be the rule, right? It should be the exception. And so for the most part, you want to make sure you get these signed prior to even putting the ladder on the house to look at the roof. And you should remember, too, that you're writing for a target audience here. The people we want to understand your agreement, we certainly want judges and other lawyers and arbitrators and anybody else involved in the claims or litigation system to understand what's in your agreement if we're going to try to enforce it. But your client needs to understand it. And there's a lot of confusion among, people who don't work on residential construction or really aren't familiar with how a house works. They get confused by the terminology you use in the report sometimes, and sometimes that can bleed into the agreement. So we want to make sure in the agreement, especially, we're using very vanilla base language to explain to people what it is you're doing and not doing, and explain some of these defenses. Keep in mind that the average American reads at a 7th, 8th grade reading level. Now, I've seen data recently that seems to suggest it might even be lower than that. I have an 8th grader. I have an older daughter who was an 8th grader. She's pretty bright. But for the most part, we're writing these agreements for people who speak at a 13 to 14-year-old level and have that vocabulary. So you want to avoid using trade terms and things that only make sense to you. But if you do have to use a particular term to describe a system component or condition, you want to make sure that you're using a term that your client will understand, or that you're explaining that term for the client in some way. Some people choose to do that with definitions in the agreement. Some people do it more in the report. And Ben, if you want to take a look at the chat and see if we have any questions.
Yeah.
while
One
we're
thing, Joe, that I've found is I've asked when I sit on the front lines and I deal with the initial claim call that comes in and discussing the circumstance with one of our insureds, I oftentimes reference their inspection agreement and ask them if certain clauses are in their inspection agreement, and more often than not, they're not sure. So I think it's important not only for the client to understand what is in the agreement, but it's hard for them to understand it if the inspector themselves haven't read through it, really try to absorb and understand what they're asking their clients to agree to.
Yeah, that's exactly right. It's important that you read and understand it, because you need to explain it. Now, invariably, you'll come across a client who will want to talk about the content of that agreement and maybe want to make changes to it. And you need to be at least familiar with why things are in there that are in there.
We had one chat question here. It said, I'd like to know if I can add this verbiage below, as I had a client that was upset that I canceled the appointment due to having 7 inches of snow on its way. It was 24 hours notice. She demanded her money back since I didn't have it in my pre-inspection agreement. So I'm not quite sure I follow the question there necessarily. It was referencing a slide from earlier.
Okay. Well, maybe if you could rephrase that a little bit, whoever had asked it, I can try to answer it as best I can.
Add this verb. So the verbiage below he wants to add, and this is from John. Quote, cancellation and reschedule policy will be in place subject to inclement weather events and other emergencies that can occur due to the detriment of our business operations, can include building fires, tornadoes, thunderstorms, snow, hurricanes, flooding. Inspection company will reach out to you either via email, phone call, and text to reschedule the appointment once the weather condition normalizes.
Yeah, I mean, really, there's no regulation. Even the states that are regulated don't really regulate it down to that level. I mean, you're certainly allowed to make decisions for, how you want to run your business and operate it, and scheduling is part of that. So that's perfectly acceptable.
All right.
Yep. We don't have Ben here. I'm having all these technical difficulties. Sorry about that. Some of the critical clauses, Ben, if you want to interrupt me whenever with questions.
Sure.
With regard to the critical clauses, some of the basic information that needs to be in your agreement includes the price of the home inspection, description of the systems and components that will be inspected, the name and address of the clients, the address of the home to be inspected, and the date and time of the home inspection. Now, we recently did an overhaul and review of the InterNACHI inspection agreements, and we'll put the link. But if you're a member of InterNACHI, obviously, and hopefully everybody on here is, you can go right into the members area and have access to all of our new home inspection agreements that we wrote specific to every state in the country. So if you're a home inspector in New Jersey, there's an agreement there that is written based on the New Jersey home inspection standards of practice, and so forth and so on. And those are free to any InterNACHI member. And we took our time with those. It took a while to put those together, but we think we put out a really good product. We had my input, Nick's input, and people, obviously we had inspectors involved in that as well. And I think they came out really good. And so a lot of this stuff, if you're using those agreements, this more will explain why things are in there that are in there. But if you haven't had the opportunity, I would say take a look at those, because again, they're free and they're written based on the things I'm going to talk about here. In addition, we're working on ancillary service agreements, and it bears repeating. I say it often, but if you're doing a service in addition to home inspection, you really need to have an agreement in some fashion for that service. Now, what a lot of inspectors do is take a base home inspection agreement and create like a rider that's 1 or 2 paragraphs about that ancillary service, because these inspection agreements in and of themselves, there's a lot of clauses that repeat. It can be the home inspection agreement, a sewer scope agreement, a termite inspection agreement. There'll be clauses in there that are the same because they're basic clauses that need to be in all agreements to help protect you and make them enforceable. And so you don't want to repeat that over and over. If you have the same client buying two services, you don't want to hand them a pile of paper that's essentially the same except for a couple changes. You can add a rider to your inspection agreement that details the scope of work for that particular service. And again, it's important that you do that because we want your client to have an understanding of what it is you're going to do. And we want to be able to prove if you have a claim that we have to deal with insurance, we want to be able to prove that you did what you said you would do. And so we want to make sure that that agreement matches up with everything it needs to match up with in order to do that. You need to have, if you're using an inspection agreement in a state that has regulations, you want to make sure that you're adhering to those statutory and regulatory requirements, including providing key definitions that might be in your statute. If there's particular disclaimers or language that needs to be in there, I know in New Jersey, again, New Jersey is always a good example of the heavily regulated states. New Jersey, Massachusetts, Texas, and Florida are the most heavily regulated. But we also have language in particular with New Jersey. I know there's specific language in Illinois that has to be in the agreement. There's specific language in the Arizona inspection regulations that say you have to do it pursuant to a certain standard. And so it's important that you make sure you adhere to those statutory and regulatory requirements. Now, we did, when we wrote the new InterNACHI agreements, look, of course, at every statutory and regulatory requirement for home inspectors. And so we, if you're getting our New Jersey agreement, it's got the right language in there for New Jersey and so on and so forth. All right, and let me see. Hold on, guys. Apologize about that. There we go. You want to make sure that you're citing, again, like I said, the exact standards of practice that are going to be used. Any statutory or regulatory based exclusions that need to be in there. I know there's at least 2 or 3 states that indicate that you have to note in the contract that you are not going to be inspecting for certain things, including environmental hazards like mold and mildew, or toxins that might be in asbestos or other asbestos containing materials. And then the state will usually dictate whether you can use additional defensive clauses like arbitration clauses, limitation of liability clauses, liquidated damages clauses, et cetera. And you'll see, we'll talk about arbitration in a second. We did not include arbitration clauses in the new InterNACHI agreements for a reason. But you can certainly put one in if you feel that you want to have one, or if your insurance carrier requires it. We don't. At the InterNACHI Elite Insurance Program, we don't require arbitration. That's why they're not in ours. But if you require it, InterNACHI has a clause that you can use that I've given them, and we'll certainly provide it to you upon request. And liquidated damages or limit of liability is the clause that says, even if you're right and I did something wrong, the best you can get is a return of the fee or some multiple of that. They're useful in different states. In some states, you're not allowed to use them. In some states, you are. And so we looked at that when we did the InterNACHI agreement as well.
Hey, Joe.
Yeah.
So in a state like New Jersey, for example, you can't use a liquidated damages or limit of liability clause, correct? Or for the,
New Jersey,
the inspection fee?
Yeah, New Jersey, it's even worse than that, because what happens in addition to that is New Jersey has a couple of consumer protection laws. One is called the Truth in Consumer Contract Warranty and Notice Act. And what judges have found in New Jersey is that the mere inclusion of a limitation of liability clause violates that consumer protection statute, because the New Jersey Appellate Division Court has already, you can see how complicated this is already, but a New Jersey court decided that any limitation of liability under the insurance requirement of $500,000 is against public policy and void. And so the New Jersey courts have now said that that also means that if you included it, may be a consumer fraud violation as well.
So on the one hand, the state of New Jersey requires $500,000 of E&O insurance. So if that's the case, a home inspector limiting their liability to the cost of the inspection fee or a multiple would then be violating consumer law, which basically contravenes the Licensing and Insurance Act.
Yeah, it's very convoluted, and I really wish before I stopped, day-to-day litigation work, that I had a chance to take a crack at that at the New Jersey Supreme Court level, because I think we could have flipped it. But yeah, essentially what they decided is, because the legislature, when they created the New Jersey home inspection licensing law, said you have to carry at least $500,000 of E&O insurance coverage in order to be an inspector. Because the legislature set it at 500, it would be against the legislative intent of the statute to allow an inspector to limit their liability under that $500,000 minimum insurance.
Okay.
And so what it means is you can't limit your liability to anything except up to $500,000, which of course is useless in the home inspection context because we very rarely see cases of that magnitude with home inspections. We do. I mean, we certainly get death cases and things that we've had to deal with. And I see every claim that comes into our inspection or to our insurance carrier. And yeah, and in my career of practicing and representing home inspectors, I've dealt with death cases. So it's important that, you know, we keep in mind that the most cases are never going to hit $500,000. And so what New Jersey's done is essentially said, every time you walk in a house, you're exposed to $500,000, whether you like it or not. My theory always was, you know, if you want to keep home inspections affordable for everybody, Bobby and Susie, first-time buyer with 3 small kids, etc. In order to do that, there needs to be a trade-off. And that means that, you know, if we're going to do it at this price, we need to have some insulation from our liability for doing this job. Because if inspectors charged what they really deserved, we'd be talking about thousands of dollars for each inspection based on the risk you undertake. And so as a public policy matter, if we can limit the inspector's risks so they can keep the price down, it does decrease the litigation between buyers and sellers. Because if home inspections aren't affordable, people are going to get them without an inspection, just like you saw in this market where they had to give up the inspection in order to buy a house for a few months. What's going to happen is you're going to have the courts flooded with cases between buyers and sellers and against agents for non-disclosure. Home inspection plays a critical role, not just in insulating the buyer, but it insulates everybody in the transaction because you're an objective reporter of the conditions based on your experience and training. And so, you know, in my mind, it's a valuable service and there should be some trade-off on the exposure. But as it stands right now, I think probably about 25, 26 states, we can still limit liability. Some are better than others. Texas is far and away the best one. Right after that is a state like Pennsylvania, and there's several other states.
Illinois.
Illinois is great. In fact, we just got, you know, one of the things you have to do when you own your own insurance company and you defend your own claims is you better have really good attorneys representing your insureds. And, you know, that's how my practice ran primarily on that for many years. And so I'm hard on the attorneys that we pick for our panel. We had a real ace in Chicago and not only got the limitation of liability enforced in a Chicago court, which is tough, but in addition to that, got a ruling that they had to pay, that the claimant would have to pay the inspector's fees if they couldn't sustain the lawsuit. And the judge gave us a written opinion, which means we can use that and cite to that in other cases. So that was tremendous, but that's all part of the risk management, you know, aspect of what we do as an insurance carrier. In addition to making sure these agreements are right, we make sure we have the right attorneys representing you so we can get the best result for you possible. So when we're talking about communicating the scope in the agreement, one of the things we want to do is define the services being offered. And again, cite the standards that you're going to use. If you're in a state like Colorado with no regulations, you're going to use the InterNACHI standards of practice. That should be so cited in your agreement. You'll see, if you do look at the agreements we've provided, if you're in a state with no regulations, they default to the InterNACHI standards of practice. And so what you'll see in that agreement is a lot of the language pulled right from the InterNACHI standards. I'll apologize if you can hear my dogs barking in the background. Our office, we blew the water heater and flooded out the office over the weekend. So we're all working from home again. And so I apologize in advance for any background noise you might hear. This is just an example, again, using New Jersey because they're so heavily regulated. This is language that actually has to be, and it's this language right here. Home inspectors, home inspectors, there we go. It's this language right here. Home inspectors are governed by the rules in the New Jersey Administrative Code, and the licensee shall comply with these rules. This is specific in the New Jersey home inspection regulations. It says you have to have this word for word in your agreement. And so when I talk about your state having peculiar things that you might have to do, this is one of those things where the New Jersey agreement has to have this language in it. And so this is what I mean when we talk about communicating the scope of work within the body of an agreement. Okay. Now let's see some of the other critical clauses here. There we go. Now, if you are in a state that has its own regulations, you don't want to double up. You shouldn't be putting that we're going to do it according to the state regulations and the InterNACHI regulations. The InterNACHI regulations, if you're in a regulated state, the InterNACHI standards will fill in the gaps. So if your state is silent on a particular issue, you can use the InterNACHI standards to fill in the gaps. But if you're in a state that speaks to every issue related to your scope of work and exclusions, then you're just going to cite to that state standard of practice. Pennsylvania is a good example where there's a law in place, but they never set the standards of practice. You can use InterNACHI standards of practice as you know, your schematic, so to speak, for doing your work. The laws of your state are always going to be primary, and any other regulations are going to be secondary to those. And at the best they can do is fill in the gap where there's an issue with the state regulation or a gap in that regulation. And this is just something that talks about, again, an example of how we describe for a client what will be in the home inspection report. This is an example from a state that had certain language that was required. If you're in a state that's not regulated, in the InterNACHI agreements that we did, we defined this, the report as, you know, what will be observed and deemed material, like it says in the InterNACHI standards. Ben, I see a few questions in there. Will the slides be available to us? Actually, the ones that are available to you are already online. We recorded a shorter version of a discussion of inspection agreements within the body of some of the videos we just put up on the InterNACHI website. So they're there, but if you want to shoot me an email after, and my email will be up in the chat. Ben's going to put our email addresses in there. If you want to send me an email after, I'll send you a PDF of the slides, sure. Also, how does California compare? Well, California has regulations, but they don't have standards of practice. And what that means is that in our agreement, you would see that we cite to the InterNACHI standards of practice as the actual standard and the California law, but the California law doesn't say what you have to do and not do. It does say you can't limit your liability to the cost of the inspection, but it doesn't get into too much other than that. So California, in terms of claims, not our worst state by far. I'll tell you right now, we just did a review again, end of month review for January, and once again, New Jersey is far and away the leader in incidents and claims in our program. Followed after that by Tennessee, of all places. And I'm still trying to wrap my head around why Tennessee is so bad. Ben, you have an interesting theory on that, right?
Yeah, it's probably everyone moving from New Jersey or California.
Yeah.
People are leaving California, where I live, left and right, and moving to places like Tennessee, and they're buying houses sight unseen, and then taking that risk, and then finding out that what they thought they were buying and what they actually bought are two different things. And what better person to blame than a home inspector for something they didn't do their due diligence on as a buyer.
That's right.
So again, I think that just gives credence to the importance of having these agreements signed, having them delivered in a timely fashion, and making sure that everyone, chances are they might not read it, but at least you can say it was delivered in a timely manner. If consumers, I feel like in today's world, and I think I'm one of them, whether I'm checking into a hotel, renting a car, updating my Apple software, I could probably give whatever vendor my firstborn child, not knowing what I just signed my life away to. You'd think that people that are making the biggest investment of their lives in a home would read everything, whether it's the agreement, the report, that they would read these things thoroughly, and I just don't think it happens. And I oftentimes ask inspectors, who has read your insurance policy cover to cover? And if I was sitting in a room full of 50 inspectors and asked that, maybe one will have, two maybe. So the point being is, we have an expectation to some degree that you understand what you're buying from us from an insurance policy, just like you have an expectation of your clientele reading your inspection report and your agreement. But consumers generally will look for the highlights, look for anything, just the Cliff's notes, and not do their due diligence and do all the reading that they should with an investment of this magnitude.
Yeah, I think that's right. I'm always shocked and amazed by that. And listen, I mean, I'm no financial guru, but if I'm making an investment, north of in the six-figure range, wherever you may fall, or seven-figure range, I'm kind of want to read the prospectus on my investment. I want to see, what an expert in the field of home inspection wants to tell me, and more importantly, I want to hear from the experts that the inspector is going to tell me I need to retain to look at specific issues like structure and foundation and the roofing and the roof structure, because that's where most of our claims come from, or structure and roof. When we talk about, in your agreement, you want to cite the exclusions. And I mentioned earlier about, how the InterNACHI standards of practice fill in the gaps. There's some states, Florida is one of them, Arizona is one, that aren't real detailed on the exclusions. I'm sorry, not Arizona, Illinois is one. They're not real specific on the exclusions. And so they kind of leave it up to the inspector to put in their written agreement what it is they're going to do and not do. And so you want to make sure that if you're in a state that doesn't have its own set of exclusions, you're using at least the InterNACHI exclusions, because you want to make things clear to the client, particularly in terms of the things you're not going to do. So if you take a look at the InterNACHI agreements, the ones we did for states with no regulations, you'll see those exclusions, and they mirror sometimes word for word the InterNACHI exclusions. In the states that are regulated, the agreements we did there, if they have exclusions, we've put them in, and we've filled in the gap from time to time with some things that state might not have thought about. But you want to make sure that those exclusions, at least the general ones, and what I'm talking about are, the inspector is not going to move furniture. The inspector is not going to take actions that would impact the inspector's safety or the safety of anyone at the home. The inspector is not going to take actions to destroy the condition of the home. The inspector can't go in a space that's less than, a certain amount of access. All those things are the things that really should be in your inspection agreement, because those things are universal. No matter what system or component you're inspecting, these things will apply to the whole job. And so you might have limitations caused by visual inspection. Like I said, you're not going to move things. You're not going to remove wall coverings, ceilings, or floors, and so forth. Safety issues, like I mentioned, it's unsafe for the inspector to walk the roof because there's snow on it. You're going to put that in the agreement. If there's an issue because of pests, like you look into the crawl space and you see eyes looking back at you, that's something that, again, would be a safety issue, and that would apply universally no matter what system and component you're looking at. We generally don't opine on life expectancy of systems and components, although I do often see inspectors in their reports that I get in for claims, and I've had many claims related to this, tell people how old the roof is or how long it's going to last. And we do get a lot of claims where they come back and say, well, you told me it was, I had 25 years, and a roofer came out and told me that was wrong. I only had a year of life left on this roof. And in some situations, when you make that, that representation to your client, even though you're not required to, you may be buying that liability. And so you want to make sure, if you're giving life expectancy for any system or component, you want to make sure you have a very, very good resource to back that up. And then, of course, we're not obligated to talk about the causes of any conditions, deficiencies, or material defects we find during the course of the inspection. That's up to your client to do with another expert or through their own investigation. And some of the other exclusions that you should mention in your agreement: you're not going to predict future conditions that may occur. I just got one in where yeah, the inspection's like 18 months old, and it's a condo with an exterior deck, and our insured inspected it 18 months ago, and there were some issues there. Hanger joists needed, and some other supports needed, and there was a recommendation as to, increasing the load capacity by, adding some things to that, and recommending that they take it to a deck contractor. And of course, they didn't do that. But now 18 months later, the deck's starting to come away from the building. Well, yeah, things change. In 18 months, things might change. At the time our insured was there, I mean, it looked fine, and we have the photographs to back that up. But that's when I say it's also good to put this in the agreement that, the client needs to understand that things may change in the future. Homes are subject to the elements, they're subject to living in it, they're subject to damage, they're subject to displacement from the soil. There's a lot of things that can go on in a home, and especially over the period of 18 months. Now, that's why in the agreements we just wrote, where we're allowed to do it in particular states, we include a clause in there that says that you agree that you will not bring any litigation against us more than 1 year after the date of the delivery of the inspection report. The reason we do that is because, number one, we want to cap that time period, because things can change so dramatically over time that it's unfair, for an inspector to have to defend against the condition of a house 5 years later when they saw it, 5 years before, and we know things can change. In almost every claim I get with a contractor, they're telling these people that, well, your inspector should have seen this. There's no way this wasn't here X number of years ago. I mean, I even had one guy literally under oath in a deposition try to argue to me that he saw ant droppings in an attic. And from that, he was able to tell that this water and moisture condition had lasted for several years, which of course forced me to have to ask him about his, history of training in ant frass, and, what studies he did, or what scientific work he did to make that determination. And it unravels very quickly. But there's still people out there who will use that tactic to try to bring a claim against an inspector. And so we want to make sure that it's perfectly clear that, we're not dealing with future conditions at all. And we also disclaim operating costs. That's not our job to tell you how how much fuel oil your furnace is going to burn over the course of the winter of 2023. That's just something we don't do. Code compliance. Although a lot of the things we report touch on codes, the reality is we're not bound to cite code as a particular reason for a material defect. And the reason is, codes change. It might have been fine when this house was built, but it's different now, and you can't judge it based on current codes. That's why inspectors instead are focusing on safety and habitability issues rather than code issues, though those may overlap. And of course, we don't report on market value. And we don't report on, or we don't perform any destructive testing in the property, primarily because most of the time you're doing it for the buyer, and the buyer doesn't own that property that you're being asked to destroy with destructive testing.
I think we had a request to critique a home inspection agreement from one of the attendees here. So I just asked to email that to you and myself.
Okay.
Unless you're seeing something different than I am.
Wait, I'm sorry?
Unless you're seeing something different than I am on the chat. The last question was just asking for a critique of an agreement.
Okay, good. Yeah, you can, if you're one of our insureds, you can send that to me. My email address will be up there, and you can send it to me and I'll take a look at it. We do review the agreements for our insureds. Some of the other general exclusions that need to make it into your agreement, and here's just an example of that. We created that I can't remember which state this was from, but this is just an example of how somebody put up, the general exclusions and things in their agreement. It's a little bit difficult to read this way. I would say maybe if you could break it up, and of course it's an InterNACHI one, which, I mean, I can't take credit for what goes into their agreements. But this is an example kind of how it lays out, but when you look at this, it looks like it's just a pile of words. And what we tried to do in the InterNACHI agreements was change that and, separate these things out a little bit according to section, or, put different letters in there or something in there to break it up for the reader, so it's easier to comprehend and understand when they receive it. This is just an example of an exclusion where an inspector was trying to explain to the client that, we don't remove finishes. And so that's the drywall, the paneling, suspended ceiling tiles, etc. And so we have that up there so that, or we have this in the agreement so that the client understands that we're not going to do anything here that relates to moving things that don't belong to you. Now you can do this in any number of ways. I pulled this from an inspection agreement that was involved in a claim of ours. And this was helpful because, part of the claim was that the inspector was supposed to move suspended ceiling tiles. And, the inspector put right in the agreement, I'm not going to do that. And so it was kind of hard for the plaintiff to argue that they had a different understanding of what the scope of work was going to be. Now, this is just an example of, somebody excluding environmental issues. And so you can see the laundry list: asbestos, radon, lead, urea, formaldehyde, mold, mildew, fungus, odors, noise, toxic or flammable chemicals, water or air quality, PCBs, and so forth. This is just an example again from another claim where somebody was explaining to the client that they didn't do any kind of hazmats. And then, in addition, this was a mold claim, as I remember it. And so right there in the inspection agreement, it was in a state where they don't have a set of exclusions in the statute for home inspectors for the regulations. So the inspector had to do it. And the claim was about mold, and there it was. We're not there to find mold. Now, the argument usually then becomes, well, yeah, it wasn't that you were supposed to find mold, but you were supposed to find the water intrusion problem that led to mold. And that's true as long as it's visible and readily accessible to you. But for the most part, unless you're getting paid, you're not there to look for mold. And so that's usually one of the hazmats that are excluded. I would say to you that if you're doing your own agreement, you want to be specific about these hazmats. You don't just want to say hazardous materials. You don't want to leave it open for a judge or an arbitrator to make a decision about, what your agreement says. And while we're on the topic of arbitration, I'll speak to that a little bit because I mentioned it earlier. We didn't include arbitration clauses in our agreements. There's pros and cons to arbitration. The big cons are that you can't appeal the decision. So if the arbitrator makes a mistake about the application of the law to your case or any other error that's not fraud, you're stuck with it. And so in the world of home inspectors, we have all these states that have specific regulations and they're the law. And so if the arbitrator makes a mistake on interpreting or applying those standards, or makes a mistake where they should have enforced a limitation of liability agreement in a contract and they don't, we can't appeal that. We're stuck with it. We have to live with it. If we're in a court and that happens, we have an appellate court to go to, or the state Supreme Court if we had to try to make sure that justice is being done and that you're being held to the standard you're supposed to be held to. The other problem we've run into with arbitration is that they will not allow us to file motions in advance before we have to spend all the money on, defending the case. And so what happens is, in court, the plaintiff files a complaint, we file an answer to that, or we might file a motion if that state allows us to try to dismiss the case based on any number of defenses we might have, usually the ones that are in your agreement, like limitation of liability. If we can enforce limitation of liability in the beginning of the case, well, it's less likely the plaintiff's going to pursue that and spend a bunch of money on their lawyer and a bunch of time when their best day is going to be a refund of the fee. And so, these claims, they accumulate dollars and value and cost because we have to hire attorneys to represent you through this whole litigation process. And obviously, if we have to do it for a year and conduct discovery, which is the process where we spend most of the money, that's where you're, producing all your files, we're taking depositions of witnesses and parties to the suit, we're hiring experts, we're making evaluations. All the money in litigation is spent right there. And so if we have a situation where we're in a state that allows limitation of liability, and we have an agreement that's written appropriately to enforce that, well, if we can enforce that at the beginning of the case, we're going to avoid all of that discovery expense. And the reason it's good for the insured is that's how your premiums go up, is when you have a claim where we have to spend a lot of money defending you, or we have to pay a lot of money toward a settlement above your deductible. And so if we can eliminate that exposure, we can keep your insurance rates way down. and the insurance rates for everybody way down. But in arbitration, they rarely, if ever, in fact, I can't think of an occasion in the last 10 years when an arbitrator has let me do this, is file a motion in advance to let the arbitrator decide on the limit of liability, because once they can do that, well, then, that might be the end of the case. And because we generally can't do that in arbitration, they want to make us do our discovery and have our whole hearing before they'll rule on that issue. And that's a reason why, we like to avoid arbitration. Now, if you're an InterNACHI member who's not insured with us, you need to check with your insurance provider. Some of them require you to have an arbitration clause in your agreement. So if you're one of those people and you're unfortunately not insured with the InterNACHI program, I'm happy to give you an arbitration clause you can use, or better yet, you should contact your insurance provider and ask them for one, and put it in there. But we didn't include it automatically for the reasons I just said. If you are one of our insureds and you feel strongly about having an arbitration clause, we're fine with that. We're not here to muck about too much in telling you how to run your business. So if you want to have one, by all means have one. And if you need one, I have one, I'll give you. But other than that, we didn't include them automatically in the agreement. Let's see, it looks like there's a question. Again, about the slide deck. Yeah, Ben will have my email address in there and you'll be able to get a copy of the slide deck. This is just another example of how an inspector excluded environmental hazards in their agreement. Again, I would say to you, plants and biological activity, I would be more specific about mold. Mold, I'll tell you right now, the hazmats we see the most of in claims in our captive insurance company. Again, this is the benefit of owning your own company, is you see every claim and you digest what goes on in it, and you try to adjust your training and education and risk management advice to match what's going on. And so, in this instance, I would say for the most part, it's asbestos, lead, and mold are the three typical hazardous materials that we see in claims in our carrier. Mold being far and away the most prevalent, but asbestos too, because we have inspectors in states where asbestos wrap was used on ductwork and wrapping boilers, large boilers and things to insulate them, and used vermiculite. Some of the vermiculite has asbestos containing materials in it. We still see that. And it creates, a problem. And I would say to you, if you're looking at the clause we have here, it's good for animals, insects, birds, pets, mammals, that kind of covers the gamut of what we might see living in an attic or a crawl space or a basement. But it doesn't really get to the issues of, toxic materials here. And so I would say, you want to say mold, mildew, and similar similar conditions. You also might want to say, asbestos or other potentially cancer-causing materials, or if you're not doing radon testing, a provision there that you're not going to test for radon. But I would be more specific than this about the things you're going to exclude. Now, again, if you're going to use the agreements we've prepared for you through InterNACHI, they have the clauses in there that strike, mold, mildew, asbestos, and all these other problems as your state has required it. And so if you're in a state that's regulated, you'll see those exclusions tend to match up with that state regulation for the most part. And if you're in a state that's not regulated, you'll see the InterNACHI exclusions in there, and they include, plants and animals and other toxic things that are bad for your health, so to speak. And this is just one we had written, actually started in Ohio. We started to get claims for meth labs where there was a flip house or an estate sale, and the inspector was supposed to tell them that it was a meth lab. Now, I know there are some of the labs that act as vendors to the inspectors. The inspection industry offer meth lab testing and things, and so I'm sure it happens. But we had a rash of these, and so we were trying to insulate the inspectors from liability for that. And so we had written this, that, basically we can't be responsible if the house is rigged to grow marijuana if you're in a state that hasn't legalized it yet, or make methamphetamines, which is the much more harmful one because the chemicals leach into building materials and paints and things and can be deadly. So we had to insulate people from that, and that's where we came up with this clause. And I'm happy to provide this to whoever wants it. And then you'll often see a clause like this in the agreements, and this is just a clause basically requiring your client to reach out to you within 10 days, or to give you 10 days rather to come back and look at a condition that they're making a complaint about. And the reason we put this in there is because, number one, we don't want them to repair the condition before they give you notice. Otherwise, we may not have good evidence of what the condition looked like when you saw it versus what it looks like when their contractor starts ripping it apart or completely changes it. And so we want to give you the opportunity to get back out there and see this condition before it's changed. Now, that's not always going to hold up. If there's a flooding event at the home, or a burst, like in our office, it just happened, a burst water heater. That's an emergent condition where a court's probably not going to enforce this if they go get repairs made right away. But more often than not, it's going to be a condition that they can give you notice of. And we do this again so you can have an opportunity to see it before it's changed. And so if you have an incident or a claim with us, one of the first things we ask you to do is get back out to the site and get as many photographs as you can and get a good handle on what the complaint is. Now, a lot of inspectors do that on their own before they come to us. But, if you do have an incident or a claim in our program, we encourage you to report everything because we don't count everything as a claim. It's not a claim unless we have to spend money above your deductible for whatever reason. So, it's better if you report everything to us, and then we'll walk you through this process where, we'll help you get, make the arrangements to get out there and and we'll talk to you about, the evidence and the photographs you need in order to best defend yourself against the coming claim. I see it's about almost 1 o'clock and we were going to stop at 1. So if anybody has questions they'd like to ask us, or if you want to post those, feel free to do so. Ben, you probably already put in the chat the email addresses and everything, right?
Yep.
Okay.
Let's see. Insurance to another. I have one question here is I have insurance to another company. I just became an inspector. I do not have a pre-inspection agreement yet. Can your company do this for me?
No, but InterNACHI has already done it for you. If you're an InterNACHI member, you can have that agreement that we just wrote with Nick for free. So you can get that right from InterNACHI directly. You don't have to worry about getting it from us. But again, I would recommend to you that when you get that you check in with your insurance company, because some of them, they like to tell you how to run your business and require you to do certain things. And so we want to make sure that, I don't want you to put you in a bad space with your insurance carrier. So make sure you check with them about arbitration and other things before you use that. But again, the InterNACHI one's free, and I helped create that. And so you don't need to be an insured. You just need to be an InterNACHI member. If you're insured with us, then we'll help you if you need custom things done with it. If you need to add things that are particular to your business, or you need ancillary service agreements like termite, radon, et cetera. We do those for our insureds.
Joe, there was Richard Graff in Pennsylvania said, I'm in loosely regulated state Pennsylvania with my agreements and ancillary addendums where we're all written by Joe for ASHI standards in the state of PA and Delaware where I inspect. If any of these new statements and clauses you have added to the NACHI agreement are not included in my agreements, is there an issue with adding them?
No, there's no issue with adding them. We always understand that with anything related to these agreements in particular, and risk management and claims, it's an ever evolving situation. And a lot of what goes into the agreements is based on the experience that we've had up to that point. Now, the reason we overhauled all the InterNACHI agreements is, our InterNACHI and our collective experience has been that, we've learned a lot of new things since we started this insurance company. And now we don't have, the big insurance carriers of the world, handling all the claims and giving us limited information. Now we see everything. And so we took the 3 years experience we have in this captive insurance company together and put that into these agreements that we just rewrote and put up. So, if you're an InterNACHI member and you're doing the inspection according to the InterNACHI standards, you would want the newest InterNACHI agreement. But agreements I've written in the past are still enforceable. There's been no big structural changes in any state's regulations. Illinois just went through some, and New Jersey just went through some, and the Ohio ones are relatively new, but there hasn't been any big wholesale changes in any state home inspector regulations pertaining to contracts and contracts. So to answer your question, there's nothing wrong with you adding these new things to your existing one if it's one I wrote in the past.
What do we know where Nick posted the InterNACHI inspection agreements, the current revised one?
Yeah, hold on. Why don't I get out of this and I'll pull that up for everybody. Okay.
While you're doing that, Joe, there was another question that reads, if you advertise and using infrared, should you have a clause as infrared can only work in certain conditions?
Well, you should always include in there that you should always include it with IR. You should always include something to the effect that the weather conditions or surface conditions, particularly with the roof, can change the results dramatically or affect the results. This is the wrong one. Let's see. There we go. Okay. Let me just pull the link for you guys. This is the page. You're still seeing my screen, right?
Yeah.
Yeah, so this is the page here, and then I'll put the link in there.
Thank you. That's different than the page that I had from when you guys updated it.
Yeah, now again, this is a member area, so you have to be a member to be able to access this. But I just put it in the chat. And these are all the new ones. And you can see here, every state we have one. And so, for example, let me see if I can get in there from here. If you're a member, you'll go, I put the link in the chat, and that'll take you to this page. And like I said, you'll be able to see any of these agreements. Because I have editing abilities, for me to go in here and open one of these for you, I got to go through a whole two-factor authentication thing that's going to blow a lot of time for us. But this is what it looks like. And you just click on the agreement you want, and it'll be populated with the language we created specifically for that state. And so you'll see, I don't mind showing you here what they look like. Let's just use Alabama. All right. Yeah, again, sorry, folks, I'm jumping around a lot with this stuff, but with my office being flooded, I'm kind of... So you can see here, let's get that bigger. This is generally what they look like. And so a lot of the language in the agreements is the same. These first two paragraphs are the same for everything. Where things start to change a lot is in the scope of services. Now, Alabama has regulations for home inspectors. And so that's why in the scope of services in the InterNACHI agreement for Alabama, we cite to the Alabama Department of Finance Construction Management Division Administrative Code. That's the Alabama standards. And so from that, we're able to see what Alabama requires for your report. And we put that in there. And the exclusions that Alabama requires, along with our rewriting some exclusions based on some of our experience. Talk a little bit about third-party service providers. That's common to every agreement. Something in there about your fee, because if you are charging interest for unpaid fees, I mean, most inspectors are paid before the report goes out. But if you run into a situation where for whatever reason you weren't, you need to have something in your agreement that says you're allowed to get interest and that they have to pay your fees if you have to take them to court for that. And so that's why this is in there. We talked about limitation of liability and liquidated damages. Alabama is a state where we can use it, and so we include that in the agreement. We talked about them giving you notice of a claim, and you'll see that's where that appears here, and that's in every one of the InterNACHI agreements we wrote. And then some basic, legal language. Then if you wanted to include, some kind of a rider for ancillary services, well, you might say, for example, here's a rider I created to go along with this agreement that is specifically for a wood destroying insect. And it's Alabama's, well, I don't remember for sure about Alabama. Most states, you use form MPMA 33. And so if you're in a state that's what you use, our WDI rider would then be attached. And again, as you can see, instead of repeating all the same stuff that's common for both agreements, it just speaks to the exact things for WDI in this rider, and you can attach it. And that way you don't have to give your client two, 3 or 4 page agreements. You can just give them the rider when you're doing that add-on service. And so we're about to the end of, we're over. And that I saw the advertising or the IR. So that looks like the last of the questions. Again, if you want to reach out to Ben or I, we're always available to talk about risk management. If you're an insured of ours and you have questions about, your inspection agreement or claims, you can definitely email me. If you have questions about our insurance program generally or what we offer and what we do, including the worry-free reporting, the free 5-year tail if you're in the InterNACHI program, definitely get with Ben and check that stuff out. I mean, again, the beauty of owning your own company is, we deal with the pricing, we deal with the claims management, we deal with everything. And so the buck stops with us. So if you'd like to, see what we can offer you in terms of insurance, please, by all means, get a hold of Ben. And if you're a NACHI member and you want the agreements, the link's in there for you to use. But thank you so much for attending. We appreciate everybody's participation. And if you have any questions you did want to ask here, feel free to give us a shout.
Thanks, Joe, and thanks everyone for attending.